Good afternoon, everyone. Chris Sorensen with Hainsworth Sinclair Boyd's Employment Law Team have an exciting new person on the team to introduce you to today. This is Matt Blake. Matt works out of our Raleigh office. We have an office now in Raleigh, and Matt has been practicing workers' compensation and employment law related to employers' practices for 25 years. And so Matt's going to talk to you today about workers' compensation and a number of other things that he's done in his practice. He helps all types of employers, governmental entities, private entities. He's handled a number of workers' compensation cases all the way through to conclusion. He negotiates those. He helps employers strategize how to deal with workers' compensation claims. So it's really exciting to have him here with the firm and with our team, particularly as he's able to answer a number of workers' compensation related claims as they apply to private industries, workers' compensation issues, private industries, as well as governmental. And so, he's a great advice and counsel resource as well as a defense of the employers once a claim is filed. And then he is handling also employment law matters, and he's working with us on some that are in North Carolina. And so we're really excited to have Matt and his team join us. And with that, I'll kick it off to Matt and welcome Matt to the team and everyone enjoy, and be sure to put all your questions in the chats and ask Matt a bunch of questions while you've got him.
Thank you, Chris. Good afternoon, everybody. Raven, I don't have the slides to start the presentation. But I do know that before we begin, we talk about the fact that we have over 200 attorneys in our offices that practicing in 25 areas, and we are here to serve and help you as best we can. Raven, can you get the slides up? I do not have them up.
And I'll go ahead and cover the general stuff. This is Matt's first time, so he doesn't have to do the general stuff. This is the first time doing it. So yes, make sure you put your questions in the chat. We now have a new office in Raleigh. So that's good. In addition to the one in Charleston, Florence, Columbia, Greenville, and you will get all of your credit information and also these slides and the recording from Raven later today. And so I think that's all the introductory stuff, Matt, and you can just get to the good stuff.
All right. Well, we'll see how that goes. As I said, as you guys know, I'm Matt Blake. The things we're going to talk about today is I'm just going to have a mile-high overview of workers' compensation and the ADA to start off with, and I'm going to talk about the development of workers' compensation laws, go over some core concepts on workers' compensation, and then hopefully get to the part of the program where we talk about workers' compensation and how it interacts with the ADA. And so generally, workers' compensation is a law that provides medical and disability benefits for workplace injuries or diseases. It also provides death benefits. All 50 states have workers' compensation laws. The state laws vary from state to state, but they apply to nearly all employment relationships. There's federal workers' compensation laws that cover federal employment relationships, and there's also federal laws that cover specific industries. And this presentation is really going to focus on state workers' compensation laws and how they interact with the ADA. So the Americans with Disabilities Act requires that individuals with disabilities be given the same consideration for employment that individuals without disabilities are given. It was initially passed in 1990. The workers' compensation guidance for the ADA was published in 1996, and then there was some intervening Supreme Court case law that narrowly construed the ADA. So in 2008, Congress went back and amended it to restore broad coverage. Prior to workers' compensation, things were governed by the common law. It's a body of judicial decisions that originated in England that most colonies and states adopted. A lot of the principles of common law developed prior to modern employment relationships and the common law doctrine, and many of them did not favor employees because of that. So for an employee to recover at common law prior to workers' compensation, they had to bring a negligence action against the employer. They had the burden of proof to show that the employer was at fault. They bore the cost of that litigation. And there were three big defenses contributory negligence, assumption of the risk, and the fellow servant rule that would bar the claims. And if the employee was at fault, contributory negligence was the most common one that would bar or reduce the recovery of the employee. So the risk to employers at common law was the perception of callousness for successful defense. And that sounds kind of silly, but you have to understand that in the late 1800s and early 1900s, there were labor riots and uprisings because of perceived offenses by employers. So that perception of callousness and the consequences of that were real when these laws were considered and enacted. And then there's liability based on fault with large lump sum verdicts, where you could have a profitable business, but if you were found liable for an injury at common law, you could be put out of business or bankrupt. So workers' compensation is a statutory compromise where employers and employees both gave up something and agreed to a statutory system where the employees receive a limited but a more certain benefit. And then the benefit to employers is they wouldn't be hit with those large litigation negligence verdicts. They eliminated fault as a basis of compensation, and then compulsory insurance helped distribute the cost of claims across all industry and into employers who had more frequent losses. The modern workers' compensation system is based on a German system from 1884. You can see the key components here. I'm not going to read them to you, but a lot of these are the things that are found in state systems, state laws today. In the United States, as I talked about in the late 1800s, with industrialization, states began to focus on the quality of life of their labor force. Massachusetts was the first state that had a Bureau of Labor Statistics in 1869, and they will propose legislation to help improve the lives of the workforce. The federal government developed a Bureau of Labor in 1884. They did the same thing on a national level. And if you look at the congressional record, there are reports from the Bureau of Labor that talk about the benefits of the German program. So the history of adoption of workers' compensation laws, there were early laws in the early 1900s that were deemed unconstitutional. There was limited federal coverage in 1998. 1911 was the first time a state law was upheld as constitutional. Federal coverage was expanded in 16. And then 1917 is really a landmark decision from the Supreme Court of the United States that said states had the power to replace common law liability. And with that, you saw a lot more adoption of workers' compensation. And the final 5 states were listed there. And of note, Hawaii and Alaska both had laws in place by 1917, even though they were states. Were not states. These are the core concepts of workers' compensation we're going to talk about, so I'm not going to read you the list, and we'll just go on to talk about government administration. So there's a state agency in most states that administer workers' compensation laws. Administration is just the filing of forms and compliance where there's not a contested or disputed issue in the claim. Regulation is the process by which the government agency creates rules and procedures for handling claims. And then adjudication is a process where the agency resolves the dispute when the parties can't agree as to the compensation or nature of the injury or the treatment. Workers' compensation covers employment relationships. It doesn't apply to job applicants, which is a significant difference from the ADA, and it doesn't apply to independent contractors. The threshold for having workers' compensation in most states is between 1 and 5 employees, and they may incorporate the common law of employment, or they may have a separate statutory definition. The common law definition is basically doing work for somebody else for pay under their direction and control. Statutory employment is a thing in workers' compensation where the legislature has basically decided there is an increased incidence of injuries that's not covered as an employment relationship. It's an expansion to certain areas of the economy. And what it does is puts the burden on prime contractors, the highest level contractor, to compel subordinate contractors to cover their employees. And the way it does this is it makes the higher level contractors responsible as an employer if there is not comp coverage. It doesn't create an employment relationship outside of workers' compensation. So if you have a statutory employment and a workers' compensation claim, that is not going to subject you to the ADA if there's not actually an employment relationship. Most states have injury by accident or occupational diseases as their threshold criteria for getting benefits. Injury by accident may require a deviation from the work routine, or it may not. Some states, if you are injured at work, your injury is going to be covered. In North Carolina, at least, that is not the case, and there's a lot of litigation on the front end of the claim. Occupational diseases can be named. Some you're familiar with: asbestosis, silicosis, anthrax, are things that are traditionally, back when these laws were passed, associated with employments. There's a catch-all provision in most states where if a disease is attributable to the risk of an employment and there's an increased risk in the employment of contracting it, then it can be compensable. Workers' compensation is grounded in causal relationships. It's limited to the diseases and injuries caused by the employment. There are varying laws from state to state on pre-existing conditions and whether they may be aggravated. Material aggravation is a standard that covers almost any appreciable worsening of a pre-existing condition. And then some states have a primary aggravating factor, which is a 50% or more than 50% threshold for the pre-existing condition to be compensable. And that's going to vary depending on what state your employees are in. Compulsory insurance. So this is the process that internalizes the cost of workplace injuries across all of industry. That's through the actuarial process of insurance and the mandatory purchase. It pushes costs ultimately down to consumers through the cost of products. And states usually have a mandatory private insurance purchase or self-insured status or participation in the pooled risk group. There are a couple of states, I think 4, that have state-run monopolistic workers' compensation insurance programs. Ohio is one. I want to say North Dakota, and there's a couple more. Texas is the only state that doesn't that allows you to opt out of having workers' compensation insurance. If you do that, you have to provide notices to the state. You have to post it in your workplace, and you have to tell new employees you don't have it. And then if you don't carry workers' compensation insurance in Texas, you can be sued civilly, and you don't have the common law defenses. So it's somewhat risky to have that status. Average weekly wage is just the person's ability to earn wages, whether they're earning it, and it includes allowances in lieu of wages. If you have a housing allowance or a food allowance that is not a per diem, it can be lumped into the average weekly wage. Expense reimbursements are not counted. The typical method is to look 52 weeks prior to the date of injury and see what the employee earned. And it's the goal of it is to reflect what the person was able to earn but for the injury. And so it's typically limited to a single job, and you don't aggregate wages from 2 jobs. There's some outliers with average weekly wage. If you have a recent hire, somebody who's worked less than 52 weeks, you might have to look to a similarly situated employee. There are changes in pay or position can be considered, so that if a person is promoted or they go from full-time to part-time work, and their wages are increased or decreased, you can focus on the earning capacity that they had as a result of the advancement or change in their job, the duties they were doing. And then seasonal employment is for employees who are employed for a designated portion of the year. If you base their average weekly wage on the weeks they earned, and they were paid that over 52 weeks, they would have a windfall. So they divide those earnings by 52 weeks. Compensation rate is 2/3 of the average weekly wage. If your average wage is $600, it's $400. Some states have cost of living increases for the comp rate, but most do not.
Important.
There are benefits for disability and death. Disability is a diminishment of earning capacity to occupational disease. The focus in workers' compensation is really an economic focus based on the impact of an injury or disease. Total disability means you can't do any work. Partial disability means you can do some work. And then the death benefits are to provide payments to beneficiaries if the employee's death is caused by an occupational disease or injury.
Because it has been a lifelong habit for you.
Medical benefits. Workers' compensation pays medical bills for treatment that results from a workplace injury. There's a fee schedule that's usually adopted that helps control costs, and there are laws regarding
service to your plans, but
there are laws regarding to physician selection, and the employer usually gets to pick the physician or at least pick a list or a panel from which the employee has to choose, and the employer ensures the direct care. And most states have a mechanism by which the employee can gain control of their medical care if the employer neglects their obligations under the Act. Most workers' compensation laws provide the exclusive remedy so that you, as an employer, if you comply with the provisions, you cannot also be sued civilly for the injury that occurred. That's not true for non-insured employers. And exclusivity doesn't necessarily protect employers who commit intentional torts. So those types of cases are rarely seen because the insurance coverage doesn't cover an intentional act. Is usually one of the reasons for that outcome. Healing period. It's a time from the point somebody is injured to the time they reach maximum medical improvement. You can have multiple injuries and the MMI date may vary. And maximum medical improvement is just the point where medical intervention doesn't cause the employee's condition to improve. Doesn't necessarily mean that medical care ends, but it signifies a shift from recovering from an injury to maintaining the employee's abilities. Disability prior to MMI is considered temporary, and post-MMI benefits are permanent. And the point of MMI is when many employees receive permanent restrictions. Work restrictions. When someone's originally injured, a healthcare provider can provide restrictions that will help facilitate healing. Once the point of MMI is reached, you may or may not receive permanent restrictions as an employee. Often you'll see something called a functional capacity evaluation, which helps the provider assess and assign permanent restrictions. And a functional capacity evaluation is often based on criteria that you see in the Dictionary of Occupational Titles or ONET, which are things like lifting, bending, climbing stairs, and the frequency of doing those things. And providers can set restrictions based on what somebody can do after their injury. Sometimes the provider will set a permanent restriction below what the employee can actually do, and the purpose of that is to help assure that the employee will not be re-injured. Permanent partial disability. If you have a permanent reduction in your wage loss and your wages, your wage earning capacity, you can get 2/3 of that difference for the specified period in the workers' compensation laws. Permanent partial impairment ratings is another thing that is frequently paid. That is a presumed disability. It's usually a percentage of loss to a body part, and it can be paid based on either a schedule of body parts in the workers' compensation law or based on a percentage of the whole person. And the big thing to remember that is somebody with a rating who's been paid disability is presumed disabled, but that doesn't mean they're actually disabled as far as the Workers' Compensation Act goes. Permanent total disability means if you've reached the point of MMI and you're completely unable to earn wages, you are permanently totally disabled. There are, like statutory perm partial, there's statutory permanent total disability, and these are presumed when the criteria are met. Burns, spinal injuries, head injuries are ones that you see. Many workers' compensation acts have this double body part loss is deemed permanent total disability. So if you've lost an eye or a hand or a hand in the foot, you will be deemed permanently and totally disabled under the act. And the thing to remember about this is that doesn't necessarily mean somebody under the ADA is unable to work without reasonable accommodation. So you might have cases where there's a workers' compensation award where someone is deemed permanently and totally disabled for workers' compensation purposes, but that does not mean you don't have to go through your interactive process with regard to reasonable accommodation. And if you ever have questions about that, you need to follow up, and we'll be glad to talk to you about that. The other thing is with permanent total disability, the state law may allow you to consider things like age, education, work experience. And the big one here is unrelated health conditions. And we'll talk about that a little bit later, but the scope of what your workers' compensation law in your state allows will also determine what you may or may not be able to ask under the ADA, because you have to do things consistently with your state workers' compensation. MMI and modified jobs. Before somebody reaches MMI, there's not a whole lot of concern from workers' compensation about how modified the job is, because they know the person is healing. And there are fact medical studies that say getting somebody back to work on a temporary basis is beneficial in their recovery and return to work. As indicated, the MMI permanent disability is assessed, and there's basically two approaches to payments of disability after MMI. In some states, once a person reaches MMI, total disability payments stop, and the employee has to litigate that if they want to receive something other than their rating. In other states, temporary payments continue until the employer goes to a hearing and approves that the employee is entitled to their rating. And so in jurisdictions where payments stop at the point of MMI, you're more likely to see employees attempting to return to work with permanent restrictions. The flip side of that is make work. Make work is creating a job in order to stop somebody's total disability payments. And make work doesn't reflect the employee's ability to compete for wages. And the more modifications you do to a job, the more likely it is to be considered make work. And you see make work more frequently in jurisdictions where disability payments don't stop when the person reaches MMI. So we're going to turn now to the interaction of workers' compensation and the American Disabilities Act. The first thing you have to talk about is the conflict of laws. Workers' compensation laws and the ADA both serve different purposes. Workers' compensation is a state law, and the ADA is a federal law. And so the ADA supersedes state laws that permit or require exclusion of persons with an ADA disability. The ADA doesn't invalidate laws that offer greater protections than the ADA does. And so as a consequence of that, if you have a state law that offers more protections, you cannot assert that you complied with the ADA in defense against the state law. And so with regard to workers' compensation exclusivity, that does not apply or limit the ADA. And so employers' decisions in workers' compensation cases have to abide by the provisions of the ADA. The ADA applies to employers, employment agencies, labor organizations, or joint labor management committees, which is a hybrid of a union and employer management. An employee in the ADA is defined as an individual employed by an employer, and that's sort of a generic definition that we'll talk about a little bit later. An employer means you have to have 15 employees or more within 20 or more calendar weeks. And then a qualified individual is an individual who, without a reasonable accommodation, can perform the essential functions of an employment position that the individual holds or desires. And I've bolded that because it is the language that applies the ADA to applicants. Now, there's some deference with regard to what are the essential job functions. And if you have ever had to address what are the essential job functions, you are in a much better position if you have a written description prepared in advance. employee classification, you deal with this in all sorts of areas of employment law. The workers' compensation generally relies on the common law or statutory definition. ADA applies to qualified individuals with disabilities who hold or desire employment. And as I said, the statutory language in the ADA is sort of circular. There's Supreme Court case law interpreting that type of statute, but it's not expressly been applied to the ADA. And then the Fourth Circuit, which is the circuit of federal courts for North Carolina and South Carolina, applies a little bit different test. But they're all, multiple factors that you're probably familiar with in determining whether an employee is a contractor or not. You don't really see it that often in ADA because your employers know who their employees are. Liberal construction, both acts are employee benefit acts. The ADA expressly, with the 2008 amendments, it wants broad coverage and inclusion. And workers' compensation is the same way with regard to extending benefits to workers. So we're going to shift to talk a little bit about the EEOC guidance on workers' compensation. Just a reminder, guidance is for providing clarity. It doesn't have the force and effect of law. It's not necessarily binding, but it is influential in how the EEOC is going to proceed in your case. And if you get to the point of litigation, you might be able to get around the guidance, but before the agency, they're going to follow that usually. It was published originally in 1996. It was based on the 1990 version of the ADA. And as I said, there were decisions and a congressional review. The EEOC has reviewed the guidance, but they didn't update it, withdraw it, or replace it. They put a little notice on there that says, please see that the definitions of disability under the ADA were changed in 2008. So you have to, if you're thinking about the guidance, you're looking at the guidance, recognize that the 2008 amendments were enacted afterwards, and that one of the purposes of the amendments was to restore broad coverage. So err on the side of coverage by the ADA if you're looking at the guidance for how to handle certain issues with workers' compensation claims. So the definition of disability for both workers' compensation addresses reduction in the ability to compete for wages. We've talked about it may or not include pre-existing health conditions, may consider vocational characteristics, and it can be presumed to exist as an operation of law. The ADA defines disability with three components. One is the substantially limiting, a physical impairment that substantially limits one or more major life activities. Then there's a record of such impairment or being regarded as such impairment. And we're going to talk about those a little bit more based on the guidance from EEOC with workers' compensation. The 2008 amendments included major bodily functions as a life activity, and you can sort of see how the word activity may not include bodily functions. So when they amended it, they came back and made that very clear. So after the 2008 amendments, there was a regulatory publication in the Federal Register by the EEOC that revised the regulations, and they talked about some of the factors in the statutes and how they were going to handle it. And basically, the substantial limitation requirement compares the limitation of an individual to most people in the population, and it is a common sense approach that doesn't require an exacting or statistical analysis. And so what you will see after the 1990, there was a trend through litigation that required a special burden on employees to show some of these things, and the regulations make clear that's not the case anymore. And major life activities are basic activities. If you think about that, that's a pretty broad term, including major bodily functions that most people in the general population can perform with little or no difficulty. So the definition is pretty broad there, and when you're dealing with these ADA issues, you have to appreciate that the breadth of coverage is significant. The regulations say things like advanced age, personality characteristics, environmental, cultural, and economic disadvantages or non-impairments, and these examples are from the regulation of the Federal Register publication. If you can't sleep because you live in a noisy neighborhood, or you can't read because you lack education, those are not disabilities under the ADA. So multiple impairments, mitigation, and intermittence. Multiple impairments means if you have multiple conditions that are not individually substantially limiting on a major life activity, they can collectively do so, and that will get you to the definition of disability under the ADA. Mitigating measures don't preclude the existence of substantial limitation or disability, and that just means if somebody has a disability, but they can control it through some mitigating measure, the fact that they're able to control it doesn't mean the disability does not exist. And the example that's given is medication that otherwise controls an impairment. And then episodic or intermittent impairments or disabilities that face substantially limiting while acting. And that just means if you have a condition that 50% of the time doesn't affect you, but when it does affect you, it that's substantially limiting, it can be a disability under the ADA. Temporary transient conditions. And so before I get started on this, I do want to point out that the 2008 amendments may impact this. It's not very clear, but some of it we'll discuss later. But in the guidance, they talk about impairments resulting from an occupational injury that may not be severe enough to substantially limit a major life activity, and they may be temporary, non-chronic, or have little or no long-term impact. And the regulatory publications from 2009, 8 and 9, or 9 and 11 say temporary or chronic, non-chronic impairments of short duration with little or no residual effects usually won't substantially limit a major life activity. And so then the flip side of that is that even if it has a long duration, chronic, or is permanent, it doesn't necessarily establish substantial limitation. The example I give of that is if I have a finger that is minorly fixed in a non-ideal position, but I can still do almost everything in a normal way, I have a long duration or permanent impairment, but it's not substantially limiting. And these are some examples from the publications from the EEOC, things that are temporary or transient effect to workers' compensation cases that aren't substantially limiting. Broken limbs that give them normally, sprains, appendicitis, seasonal allergies, colds, or gastrointestinal disorders. Record of such impairment. This applies to documentation of a present or former impairment. It was intended to address discrimination based on a person having a history of disability that may or may not, that doesn't exist any longer. The definition of disability doesn't require employee reliance, though if you're trying to prove a case as an employee, you probably have to show that the employer relied on the record in order to succeed. The examples that are given is an employee who previously had cancer but is now cancer-free. As an employer, you can't say, oh, you had cancer in the past, I don't want to hire you, or I don't want to give you a promotion because I'm concerned your cancer will return. The other example is a person who was improperly classified as having a learning disability. And so that record is there, even if the person does not have an impairment, an actual impairment because of the improper classification, you as an employer cannot rely on their record of having that in the past in any way to their detriment. And so that's a case where there's not an actual impairment, but the record of having an impairment is something that can be actionable if you rely on it. So here's what the EEOC guidance says about the record of impairment. In regard to workers' compensation claims, the mere act of filing a claim does not constitute a record of such impairment. The reason for that is filing is procedural and it doesn't really establish facts in any way. When you have a workers' compensation claim that's progressed to the point that there are long-term or permanent impacts, that could probably create a record of such impairment. So somewhere between the beginning of a workers' compensation claim and the end, And it's not going to be the same every time. There's a point where the handling of the claim crosses over to what may be a record of impairment under the ADA. So the guidance on regarded as, and remember this was prior to the 2008 amendment. So when you're looking at this part, you have to consider that this was changed. And we'll talk about, I think, that in the next slide. Regarded as applies where an impairment is not substantially limiting, and it centers around the post-injury treatment of an employee for workers' compensation claims. The ADA was supplemented regarded as, with the definition of regarded as in 2008, and it specified that regarded as applies to actual or perceived impairments. An actual impairment is one that exists but is not substantially limiting, and it's known to the employer. Perceived can apply where there's no actual impairment, or there is an impairment but the employer doesn't know about it. And it doesn't apply to transitory or minor impairments. This is in the statutes of the ADA. And transitory means actual or expected duration of 6 months or less. And minor isn't really defined, but transitory and minor does not apply to the other prongs of disability, which is your substantial limitation or your record of prongs. If you act in response to symptoms or mitigating measures, that can satisfy the regarded as, even if the employer has no knowledge of an underlying impairment. And then disability that's solely under the regarded as prong doesn't require a reasonable accommodation. And the reason is the impairment doesn't actually exist. But that's the only meaning to which that's true. These are some examples of the regarded as. An employee with temporary back impairment that doesn't limit lifting. If an employer disallows the employee to return to work because they believe the employee's lifting should be limited, the employee has an impairment. It doesn't substantially limit them as to lifting, but the guidance says that that person has been regarded as having a disability. They have an action against the employer because the employer based their decision on what they perceived was a limitation. This is very similar, and these are both from the EEOC. An employer has a back injury with no permanent impairment, and then the employer fires the employee from a heavy labor job because they are worried the employer will be re-injured and have total incapacity. Is there any impairment? No. Is there any substantial limitation? No, because there's no impairment. Is the employee regarded as having a substantially limiting impairment? And the answer is yes. And this is one that is really about perceived impairment. The employer fires an employee with a hand wound because they think the person has an HIV infection, and they're wrong about that. Is there an impairment? No, it's a minor hand wound. The wound is temporary and minor. Is there a substantial limitation? No, the wound is temporary and minor. But is the employee regarded as having a disability? Yes. Even though the wound is temporary and minor, what the employer perceived was that the employee had an HIV infection, which substantially limits a major life activity or bodily function. And so the relevant inquiry, according to the guidance, is whether the perceived impairment was substantially limited. The focus is not on the actual impairment, it is the perception of the employer. In example 4, the employer refuses to hire an applicant for a data entry job because of a sprained wrist. Is there an impairment? Yes. Is there substantial limitation? No, because a full recovery is expected. And is it regarded as? No. And the reason is the injury is temporary and minor. It pertains to the job, but it's also the basis of the employer's refusal. So if you can contrast that with example 3, where the actual condition of the employee was not connected to what the employer's perception was, you'll see that to get the benefit of temporary and minor, You have to have some alignment in the perception and the actual condition of the employee. So workers' compensation statutes allow medical examinations and inquiries. And typically your physician-patient privilege is something that's protected by state law. It may be a statute or it may be common law. Most often it's a statute these days. Workers' compensation laws modify the physician-patient privilege with regard to workers' compensation injuries and diseases. HIPAA regulations have a express acknowledgement for disclosure according to workers' compensation laws. And so medical records and information from an authorized provider for workers' compensation treatment under most cases don't require medical records release, and they're not limited with respect to getting the records from that treatment. If you are trying to obtain medical records in a workers' compensation matter for conditions that are unrelated to the injury or disease, you're more likely to require a release, but that will vary from state to state. In some states, if an unrelated condition impacts the person's ability to earn wages, you may be able to get those records by request without a medical release. And so the ADA talks about medical examinations and inquiries, and this slide deals with pre-employment situations where you have an applicant. You can, during the employment process, ask about the applicant's ability to perform the job-related functions. Those inquiries can only be made to the applicant. You can't ask a third party about the ability to perform their job-related functions. Pre-employment medical examinations are allowed after you have a conditional offer of employment, and they have to be for all entering employees. And what the guidance says is that all entering employees means employees within the same job category. That just means your office staff doesn't have to have the same physical exam that your loading dock workers do. And anytime you have medical information that you're obtaining under the ADA, you have to keep it in a separate file and you have to treat it as a confidential medical record. And so the ADA also talks about post or employment-related medical examinations. So these are not applicants, these are people who are actually employees, and they are generally prohibited. Employers are generally prohibited from asking whether an employee has a disability or how severe or what is the nature of the disability. And that kind of inquiry examination are allowed for the ADA specified use. And these exceptions are where the exam is job related and consistent with business necessity. And boldface that, we'll talk about that with respect to workers' compensation in just a minute. And then voluntary employee health programs and histories and things like that are exceptions under the ADA. And then you can always ask, always, but not too frequently, if the employee is able to do job-related functions. Are you able? You still have to be sure that is related to essential job function. And there's a basis for asking that. If you don't have a relationship to a job function and you don't have a basis to ask, then you're in violation of ADA. And again, you always have to keep separate employee medical files for anything related to ADA inquiries or examination. So there's the guidance from the EEOC talks about this with regard to workers' compensation, and I've quoted from it. And it says that the ADA doesn't prohibit an employer from, or its agent, from asking disability-related questions or requiring medical examinations that are necessary to ascertain the extent of its workers' compensation liability. And so basically the ADA recognizes that workers' compensation, in determining liability under workers' compensation, is a job-related business necessity. Your inquiries and exams have to be consistent with state law, and you can't ask far-ranging disability-related questions that are outside of what's permitted under state law. If you do it too frequently, it can also be harassing. And so the main takeaway there is, if you have a workers' compensation claim, under the ADA, you're allowed to make inquiries consistent with state law. If you have questions about what that is, it's best to ask beforehand than to do something outside of your state workers' compensation law and then have to face the consequences under the ADA. The one comment I will have is each state treats unrelated health conditions differently. If you don't know if your workers' compensation law considers unrelated health conditions, you better find out before you ask about it. And then inquiries about past workers' compensation claims prior to conditional offer for employment or discipline. So return to work in a workers' compensation case can trigger procedural safeguards and start time limitations. And two sides, employers and employees, may want to avoid those consequences. Stakeholders in workers' compensation claims can pressure an employer regarding post-injury return to work. And those stakeholders will be adjusters, case managers, treating physicians, or attorneys. I've capitalized attorneys there in the slide. That's my bad. EOC guidance says that the employer is the one who ultimately bears responsibility for the decisions about workers' compensation claims and performing essential job functions without reasonable accommodation. So the takeaway is don't succumb to pressure from a workers' compensation stakeholder to make a decision that's contrary to the ADA. Always have in the back of your mind, if you're handling a return to work situation, what are my obligations under the ADA? And do I have to start the interactive process? Job modification in the ADA. The ADA requires an interactive process to determine if a reasonable accommodation of the essential job functions can be implemented without an undue hardship to the employer. Reasonable accommodation is modifications or adjustments that allows a qualified individual to perform essential job functions and enjoy the equal benefits and privileges of employment. And these are the kind of things that it can include. And I'm not going to read off the list. Undue hardship. An undue hardship is a defense to making a reasonable accommodation. And it is an action that requires significant difficulty or expense when considering these various factors. And you can read over those. We'll skip them for the sake of time. And then an employer under the ADA is not required to create a new position as a reasonable accommodation. Sort of similar to the make work doctrine, except that's more of a defensive doctrine for the employee. Open light duty positions. Some employers have light duty positions they keep open for employees who have workers' comp injuries. There's often things that involve tasks that accrue slowly over time, shredding, part sorting, that sort of thing. But if you have that type of position and you maintain it as an open position, a reasonable accommodation process might require you to put an ADA, an employee who's asked for an ADA accommodation into that position. And that's typically where there's not another effective accommodation available. Qualification standards. Individuals with disabilities can be excluded from the job opportunities only when there's an actual inability to do the job. Qualification standards are generally prohibited, and it must concern an essential job function. And the way a qualification standard is allowed is a job, if it's a job-related business necessity, and it cannot be accomplished with a reasonable accommodation. And so if you have a qualification standard, what this says is you have to go through the interactive process and determine that a reasonable accommodation cannot be made. And so direct threat is a type of qualification standard. And it can require that an individual doesn't pose a threat to the health or safety of individuals in the workplace. And it means it cannot be, this is the statutory language, it cannot be eliminated by reasonable accommodation. And so there's a little bit of difference between the statutory language and the regulatory language on this issue of direct threat. Regulations extend direct threat to the individual as well as others, and they state eliminated or reduced by reasonable accommodation. And I think there's some examples of direct threat. We'll kind of go through those and help clarify that topic. So the ADA regulations on direct threat require an individual assessment. Again, direct threat is a qualification standard, and you always have to have your interactive process because reasonable accommodation is part of that analysis. It has to be based on reasonable medical judgment that relies on the most current medical knowledge or the best available objective evidence. And what I tell people about that is if you're basing your qualification standard direct threat on a 1970 medical article, you're probably out of luck. And the factors that you judge a direct threat by include the duration of the risk, nature and severity of the harm, likelihood of potential harm will occur and the imminence of it. So if someone is in great risk of harm, and for this reason, it's going to be more favorable to the employer than if there's a slight risk of harm. Those are just the factors that are looked at. Discrimination based on the risk of injury. If you refuse to hire a reinstate employee due to perceived risk of an injury or heightened workers' compensation risk, that's discriminatory. And the absolute refusal to hire or reinstate because of a prior occupational injury is discriminatory. This is from the guide. And so these are the factors that this is how the EEOC guidance says how you analyze a direct threat from a prior workers' compensation injury. And this is just a list of questions. I think we're going to skip to the next slide and go through the examples because it'll be a little more clear. Direct threat example one is a saw operator who has insulin-dependent diabetes and was seriously injured in a prior employment. That injury was due to the failure of a safety device. And so that prior workers' comp injury or prior injury is not evidence of a direct threat because it was unrelated to the impairment that the employee had. Now, this is the only example that they have written into the guidance and regulations that supports direct threat, and it's, we'll see. Somebody applies for a job busting dishes. You have to lift 45 pounds. After a conditional offer of employment is extended, it's discovered that the employee's had several past shoulder injuries, and each time the shoulder's gotten worse. And the employee was told last time, if you have another injury, you may totally lose the loss of your use of your shoulder. And so does the position pose a significant risk of substantial harm to the employee? Yes, it does. And the essential job function of lifting 45 pounds for, busting dishes can't be accommodated. So the direct threat exception would apply to this job. And you can see this was, you're not going to have many cases in actual employment that are like this. Direct threat example number 3, you have a construction company with heavy labor and where the employee had a prior minor back strain in automotive work, but they fully recovered. The injury in an unrelated industry that was minor is not going to be evidence of a direct threat to the individual in the current job. Let's turn to full duty releases. The guidance says that employees cannot require a full duty release before allowing the employee to return to work. And the reason is full duty contemplates essential and marginal job functions. And if you require full duty, it means you're skipping over the reasonable accommodation and interactive process, which is not what the ADA disallows you from skipping. You can't impose conditions that preempt the interactive process to take away from it. So leave from work is due to a workers' compensation injury is compensated. Employees may not want to come back to work, but leave under the ADA is unpaid. It can be a reasonable accommodation under the ADA. It's not required where you can provide an effective accommodation that allows the employee to remain on the job, and the employee can still take FMLA or other leave benefits, irrespective of the ADA decision. Reassignment accommodation. This is, according to guidance, an accommodation of last resort prior to termination. It's considered after reasonable accommodation, undue hardship, qualification standard, direct threat precludes return to the original position. The priority is to reassign somebody to an equivalent vacant position. You can take a lower graded position as a secondary option, and the employee has to be qualified for the position. Again, you don't have to create a new job for somebody as part of the reasonable accommodation process. Discharge, that employers can't discharge an employee who's temporarily unable to work without assessing reasonable accommodation or undue hardship. Then holding position open can impose an undue burden on the employee, but you have to go through the process to make that determination. And then talk about reassignment to vacant, equivalent, or lesser positions. Retaliation. Workers' comp and ADA have expressed provisions that prevent employers from retaliating against employees who assert their rights under these laws. Then we'll talk about permanent total disability. So, workers' compensation decisions about somebody's permanent total disability status can be considered, but they're not determinative and a substitute for the interactive process. We talked about some of the presumed disability for loss of one hand and one foot or something like that. And people who are deemed permanently and totally disabled under the Workers' Compensation Act are based on an economic determination of what they can earn. And that does not necessarily ring true when you talk about the reasonable accommodation interactive process. If somebody has settled a workers' compensation case based on permanent total disability, that doesn't alter the requirements of the ADA. So when workers' compensation claims are closed, then a person who is receiving comp benefits may not seek a reasonable accommodation while they're actually getting paid workers' comp benefits. They can initiate the interactive process. The employers can and document an employee's refusal to participate in that, or if they're choosing to stay out on comp. An employee who seeks to return to work after they've closed out their claim can trigger the interactive process. And then if you're cognizant of aggravation and re-injury after return to work, it's a good idea, if you're involved in the resolution of the workers' compensation claim, to try and seek resignation and general release with regard to the workers' comp settlement. This is a good one to remember. A workers' compensation insurer is not covered under the ADA. And most workers' compensation insurance policies give insurers control over decisions for the claims. If you have a workers' compensation claim and you're talking to an insurance adjuster, they're going to make notes about what is going on and what their communication with you is. That may be protected in the scope of the workers' compensation claim, but it doesn't necessarily mean that your conversation with the workers' compensation adjuster wouldn't be discoverable in an ADA claim. And so it's better if you're handling issues with regard to return to work in a workers' compensation claim to try and channel it through the attorney that's on the claim if there is one. And then settlements. They resolve the workers' compensation claim. Most states require the agency in charge of workers' compensation to review and approve it. It doesn't resolve and may be required to exclude other aspects of the employment relationship. But what that means is if there's something outside of workers' comp that is out there and contested, a workers' compensation settlement does not resolve it. Then a separate resignation and release can be obtained. And then there's often what happens in workers' compensation claims is there's a preliminary signed document like a mediation agreement or an email exchange between the attorneys, and then later replaced with more formal documents. If you have the opportunity to get some general resignation and release terms with regard to that. I encourage all employers to try and make that happen if they're worried about getting the employee back to work. And that resignations, voluntary resignation ends the employment relationship to which the ADA applies. States can protect against resignations that are coerced, retaliatory, or constructively discharge employees. There are certain state laws that can reinstate the employment relationship if it's determined that a resignation was not voluntary. And so if you have a resignation that you're dealing with, it should recite that it's voluntary and offers the employer some protection if that term is in there. In the release of ADA rights, the ADA does not prohibit a voluntary negotiated release of their rights. Federal case law has upheld the employee's release of rights when there's express language, separate consideration, and contract defenses do apply, but you can do that separately with a workers' compensation claim. And then that was the last one, but the tip is, it's one of the two. The tip is if you have a workers' compensation claim and you are concerned about the language in the resignation release, you can ask to have that reviewed for ADA component. And I thank you guys for attending.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.